Good morning, Byung-Woo, and thank you very much for joining me for this interview in our video series showcasing HKIAC's leadership.
Thank you, Sarah, and I'm pleased to have this opportunity and being a member of HKIAC Commission. It will be a very meaningful and interesting will be an experience for me.
We're really honored to have you on board, and with the experience and the specialization that you bring in your experience of the Korean market, both domestic and in terms of foreign outreach. So yes, I'm very happy to have you on our council. Before we get started in the interview, I want to give a brief overview of your profile.
Thank you.
So you were educated in Korea and in the US, and you are admitted in Korea and you've passed the New York bar. You joined Kim & Chang, which is one of Korea's premier law firms, in 2002. So you have spent almost 20 years at Kim & Chang. And over that time, you have gained extensive experience in terms of both representing foreign and domestic clients in international commercial arbitration. And you have worked under all of the major arbitral institutional regimes in your cases. You also advise clients both in contentious and in non-contentious matters with respect to domestic and foreign infrastructure and construction projects. And we'll talk a bit about that later. The projects that you've worked on are really global in that they span both Asia Pacific, the Middle East, and North Africa. And in addition to your work in arbitration and cross-border litigation, you are also a member of the Department of Aerospace and Defense at Kim & Chang, as well as International Trade and Customs. So really a wide spectrum of specialization. And of course, you joined HKIAC's council in November last year. So my first question to you is, you are one of the new leaders of the new generation of arbitration specialists in Korea. What would you say are some of the most important developments that you've seen in the Korean dispute resolution market over your time?
In my view, there were remarkable development in Korean international dispute market, and that can be summarized by three parts. The first one is that diversify in the dispute area and also regional reach. So traditionally, when I started my arbitration practice, the most of the international dispute I haven't seen is relating to the international trade matters, the sales of goods, and also corporate-related matters like the M&A dispute and joint venture dispute and the distribution. That's the traditional area of dispute we are experienced relating to the Korean party involved case. But last 5 years, I have experienced rapid growth of new areas like the construction, infrastructure, and also Chinese-related matters, and focused on the joint venture in China and the intellectual property dispute. And I understand that these areas, the HKIAC has a strength, and maybe we will discuss it later a little more detail. And the second is understanding of Korean users in need and the merit of international arbitration is increasing. So when I started practice, the little number of Korean users, even the big Korean corporations, they have a limited or no knowledge on what arbitration is. So there is virtually no questions about how the dispute resolution clause should be negotiated and agreed. But these days, in most the size of a transaction, there are separate questions. What is the suitable, the dispute resolution clause, and what is the most suitable, the arbitration institution for a potential dispute handling matters from our transactions. And the third one is the increase of arbitration practitioners in Korea. So as you may be aware, the first generations of Korean arbitration practitioners, including the Kevin Kim of Peter and Kim and BC Yoon and EY Park of our office, they were very successful in the establishing international arbitration practice here in Korea. But thereafter, due to the increase of a number of cases and various dispute cases, now the most of the sizable law firms has an independent international arbitration team. So, say in the past there are only the 10 years of only the less than 100 or the slightly more than 50 real arbitration practitioners here in Korea, but now there may be more than 300 or 400. So many law firms are interested in also the Seoul office of international law firms, growing their practice. And some of them surely relating to the HKIC, the practice. So that is what I can say about the recent development international arbitration practice here in South Korea.
Right. So you've really seen a change and an expansion in the types of disputes, and also just the sophistication or understanding with respect to why arbitration is the most important, well, an important dispute resolution option, as well as the population of specialists in Korea has really grown. And, you know, I think when we look at our cases at HKIAC, we see a growth in the number of Korean parties we see come through. I would say that maybe 5 years ago, we were seeing a steady number of cases involving Korean parties every year. But in 2020, that really increased by about 64% from 2019 to 2020. We saw a real uptick. And it will be interesting to see what our statistics are at the end of this year. But we've long thought of Korea as an important economy, which is why we have a representative office there, and you know, being part of that growth and expansion, like you say. And what do you think HKIAC's role or relevance is with respect to Korean practitioners in particular, or the Korean dispute resolution market? What can HKIAC bring in particular?
There are various factors the users and practitioners to consider when they need to decide what dispute resolution forum or arbitration institution to be selected for their transactional project. But I think from HKI's perspective, one of the important factor is the enforcement in China. And that concerns, I think, most of the mainland China, I mean, not Hong Kong, but that concerns are shared with most of the Korean corporations having their business in mainland China. And in that sense, I think your statistics in 2020, particularly relating to the arrangement between Hong Kong and the mainland China, imposing the interim orders of the interim measures, and the statistics of application of 37 cases, if I understand correctly, and 22 cases were successful in getting the asset preservation order, would be very important for the Korean users and the practitioners to remember. And I think that is the point HKIAC to more aggressively or diligently deliver to the practitioners and users here in Korea. And also, I see from your statistics, there is only one, the Korean national arbitrators last year. So if there is more chance for the Korean arbitration practitioners or arbitrators in serving in HKIAC arbitration, it would be great. And finally, for this point, that as I mentioned, the number of young practitioners or the partners of Korean law firms arbitration team is sharply increasing. So I think it would be helpful if there are some events by HK45 for the Korean young practitioners. There may be a matter to be discussed with the HK45 representative, Korean representative. But anyway, that is the areas we HKIAC need to consider for the relationship with Korea.
Yeah, I think, your comment about, or your observation that there are more deals between Korean parties and mainland Chinese parties is important, because what we see under the interim measures arrangement is a real success story, really, in that of the applications that have been made to mainland Chinese parties, there are freezing orders covering $1.6 billion worth of assets. So that's a pretty serious amount of assets that have now been secured for future awards. And I think any client that is interested in in assets on the mainland would be very, very interested to know about the fact that if you select HKIAC in Hong Kong, that recourse is available.
Right.
Yeah. Do you, Byung-Woo, you have been involved in so many large infrastructure and construction projects with your clients, and a lot of those have involved mainland Chinese counterparties or parties at some point in the deal. And so there we're really starting to think about the Belt and Road Initiative. And I'd be interested to hear your views on Korean contractors' role in Belt and Road projects and in Belt and Road related disputes.
Definitely, when the Chinese government planned for the Belt and Road plan, every practitioners working in the construction and infrastructure sector were very, very exciting and interested. And when I attended the seminar in Singapore more than several years ago, everyone there discussing the BRI only and not other matters. But thereafter, probably due to the influence of COVID-19, the pandemic, and also from Korean perspective, it looks like there are some priority for in project participation to Chinese parties. So Korean contractors or the other corporations' involvement in the BRI project has been limited. But I think definitely, because given the size of the project and number of projects are being contemplated, the number of projects where the Korean parties are involved will be increasing anyway. And all of them understand, in case of the project in developing countries, particularly Asia, they need the neutral and the credible dispute resolution, the institution anyway, for the smooth operation of the project. And I think HKIAC can be a good opportunity. And in this sense, I think HKIAC needs to more promote the good track record in resolving the dispute in ASEAN jurisdictions other than China is necessary or helpful. I personally have one case last year in the Philippines construction dispute under the HKIAC arbitration rules, and that was successfully handled and finally settled in the middle of arbitration for the benefit of all parties. And I think in terms of time and cost, the HKIAC arbitration procedure was efficient based on, if I compare my experience in other arbitration institutions. So I think that kind of a good track record needs to be more shared with the Korean users and practitioners.
Right, absolutely. When I look at the Belt and Road related disputes that we're seeing come through, a lot of them have a link to Southeast Asia. And I think it's, as you say, what is most important, or what is very important for any procedure, is that it's efficient and that there's time and cost wasted. And we have a number of measures in our rules and our practices to keep costs controlled, and also to keep the case moving along swiftly. And one of the cost controls we have is that we have an option as to how you pay your tribunal hourly rate or by ad valorem fee scale. and there is on the hourly rate there is a cap. So yes, it's very interesting to see those Belt and Road related disputes come through, and also to see within each dispute how different the dispute resolution clauses or options are. What's the governing law, how the parties choose to be represented, and so forth. So it's very interesting to see.
If I may, there is one more point that, as you understand, everybody shares the consensus on the time and cost in international arbitration. And after the effectuation of the Singapore International Mediation Convention, the major populations in Korea is positively considering the mediation or ADR as the format for resolving their dispute before going to arbitration. And I think the HKIAC has a good track record of resolving Chinese-related dispute in mediation. That is one other area the Korean users may want to know, because they want to resolve their dispute without really the aggressive battle and in the middle of that. So it may be another area HKIAC need to consider themselves in Korea.
You mentioned before COVID-19, and I know that for us, it meant a very swift and strong pivot to virtual hearing services, which we did immediately. The pandemic arrived in Hong Kong, and last year we held 80 either fully or partially virtual hearings throughout the year, and we've got bookings through this year. So it's really the new flavor of the day. How has COVID-19 and the switch to virtual hearings impacted your practice?
My understanding is that most of the practitioners said the COVID-19, the virtual hearing is as good as, or it's not really bad if compared to in-person, the evidentiary hearing setting. And I should share that immediately after start of COVID-19 pandemic last year, the cases were suspended or postponed. But most of these cases restarted this year. So we are quite busy that every month we have at least one virtual hearing or hybrid hearing. And based on that, I think that virtual hearing setting works quite well and more than expected. And unless there are serious concerns for confidentiality for other things, I think even after the pandemic, virtual settings will be used, one of the good, frequently used method for the evidentiary hearing for the resolving dispute. As you imagine and understand, it is helpful for saving time and money anyway.
Yeah. So my last question to you, a bit more of a personal question. So you have dedicated most of your career to working with Kim and Chang, a very interesting practice and a wide range of different disputes and different projects that you've been working on. Did you intend to become involved in international dispute resolution, or how did you come to be involved first of all in your career?
I started my career as a practicing lawyer at Kim and Chang, and I started international arbitration practice at the same time at the Kim and Chang for 20 years. So in terms of my career, there might not be many things interesting to you or the audiences, but two things I can say that Kim and Chang was one of the key players leading the international arbitration practice in Korea. So I can say I witnessed and experienced personally the major development, the Korean arbitration practice for 20 years, and may be in a good position to see what is the need and wishes of Korean arbitration users to the international arbitration institution and society. And The second thing is, as you mentioned, I focused on the construction arbitration, construction dispute for the last 10 years, and uh, contributed in the establishment best practice area in Korea and in Korean law firms. And uh, one of the good thing for me is the successfully established the SCA Korea, which is affiliate of SCA UK and International last year, and serving as a vice president for that group uh, currently. So that is the some of the highlights from my career. And other than that, there is not much differences from international arbitration practices we are meeting every year, every day. So.
Yeah, that's a fantastic achievement. And I know that our Kelly Yi, our Korean office representative, is also a member of that, of the Korean SCL group. So, you know, a really important group in Korea to represent the industry's needs in dispute resolution. It's such an important industry in Korea.
We will make an effort for for the purpose anyway, and there need a close interaction with the international practitioners, and also we are thinking that I discussed with Kelly having some event for the introducing the Hong Kong experience or HKI experience in international construction project in Korean users sometime this year or early next year. But we will see. Yeah, it is interesting.
Fantastic. I look forward to it. So those are all of the questions I have for you. Do you have any questions for me?
Right. I forgot that I should have made this remark in the first place of this interview, but big congratulations for the great result in the Queen Mary University survey this year, and the HKIAC was selected as the third most frequently used preferred international arbitration, and Hong Kong was the same. But I think, as you understand, there are some discussions and questions these days whether the Hong Kong will remain as neutral and credible arbitration seat for the international arbitration. So if you give some comment and insight, that would be helpful for the Korean users.
Sure, no, my pleasure. I understand that it's a concern that some people have or some companies have, and that they have questions as to, you know, what are the developments in Hong Kong and how and do they affect Hong Kong as a seat of arbitration. So I think those are important questions, and I have a lot of thoughts about that, but what I would say is that I think that when companies appreciate the structure and the setup of both HKIAC and Hong Kong as a legal seat, a lot of those concerns can be allayed. If I start with HKIAC, I mean, we are an independent entity under Hong Kong law. So we're independent from both the Hong Kong government, but also from the central government. So that's how we are structured. And we work financially independently. And then with respect to our governing bodies, they are international, made up of local and international experts. You yourself are a prime example of that. And for example, if I take one of our executive committee, it's made up of our two co-chairs, David Rivkin, who is an American, Rimsky Yearn, who is a Hong Konger, Neil Soliason, who is Swedish, Brianna Young, who is British and American, and Ing Lung Yang, who is Singaporean. So, you know, you don't get much more international than that. And I am a New Zealander. So we really do link HKIAC to all corners of the globe. And when HKIAC makes decisions in its cases, we are confined and constrained to making decisions under our rules. So that's predictable, and it's also finite. There's a finite number of decisions that we take in any given case. So I think that companies can take comfort from that, to know, you know, if you know who is running the institution, who is making the decisions, that can give you a lot of comfort. And we are comprised of experts across the board. And then with respect to Hong Kong, I mean, there are a number of developments. There was the National Security Law, which is a criminal law that's been put in place. But I think when you're thinking about Hong Kong as a seat, you need to bear in mind a bit of a distinction between criminal law and then the law and the structure that applies to the choice of the seat. And I think it's always important to, when you think about the seat, to appreciate also that in many cases, courts are never involved. That you may need to go to the courts for interim relief or for enforcement or for set aside. Those are, it's not always the case. And in Hong Kong, there's a disincentive to go to the courts because, to a certain extent, because the courts are very strongly in support of arbitration. And if you bring a set aside action in Hong Kong and you are unsuccessful, or if you try to challenge the enforcement of an award or even an arbitration agreement and you fail, you will have a costs order against you. Right. That's the default position. It's a disincentive. It's very strong. So you don't get a lot of frivolous cases coming before the Hong Kong courts. Mm-hmm. And the other thing that I think is important to know about Hong Kong is that when you bring an arbitration-related case to the Hong Kong courts, you will find yourself before specialist judges. So specialist arbitration judges who are from Hong Kong, but they may be from other jurisdictions. For example, one of the most recent appointments in Hong Kong was of a British barrister who had been doing a lot of arbitration work, and he's now on the bench. So that's who you find yourself in front of. And it's very, those judges are highly seasoned, highly trained, and there's no realistic worry that they would be unduly influenced by outside forces. They are applying the law. And then when it comes to the law, the law that they're applying is the Hong Kong Arbitration Ordinance, which is based on the ANSI trial model law. And in Hong Kong, there is really a long record of case law, a strong body of case law with respect to the ordinance. And so it's relatively predictable how the courts are going to act. And the courts have also a long record of being robust and making strong decisions in support of arbitration. So, for example, the Hong Kong courts have injuncted proceedings outside of Hong Kong, including on the mainland. The Hong Kong courts enforce awards against all kinds of entities, including the Hong Kong government, including mainland Chinese entities, including mainland Chinese state-owned enterprises. So that's all a matter of record. It doesn't perhaps make its way into the international press as much as the national security law or the protests do, but it is the reality. And so I think that, companies can take a lot of comfort once they understand what is going on in the area of law in Hong Kong that concerns them, and to know that things have not changed. The courts are acting as they always have. And what's more, it's absolutely important that companies know that if they do select Hong Kong, and if they are concerned about assets or evidence or conduct on the mainland, it is only Hong Kong as a seat which would offer them recourse to interim relief from the mainland Chinese courts. And you and I have already discussed the figures coming out of those applications. Those are very important and those are commercially significant. And of course, companies have to be commercially minded. So it would be a catastrophe if a company misunderstood the reality of Hong Kong as a seat and didn't benefit from what it can offer.
Right. I think what you said is basically the same or similar as my understanding, but your statement as a Secretary General should be more persuasive and give more confidence and assurance to me as well as the Korean users. So that should be very helpful with the future consideration of international arbitration institution.
Well, thank you so much, Byung-Woo, for your time. And thank you again so much for being a part of HKIAC's governing board. We're very happy to have you on board, very privileged, and we very much look forward to working with you in the years to come.
It's my honor, indeed. And I hope there are more opportunities to work together for the HKIAC and the international arbitration practice and society. And if there's anything, just let me know. Thank you very much.
Thank you.
Okay, have a good day. Bye.
Thanks, Byung-Woo. Thanks so much.